Okay, I'm going to go ahead and get us started. I see people are still logging in, so I will do a slow hello as people continue to come into the room. But I want to welcome and thank everyone for joining us in today's discussion, Realizing the Promise of State Reproductive Freedom Amendments. My name is Diana Kazin. I am the Legal and Policy Director of UCLA Law's Center on Reproductive Health Law and Policy. And for those of you who may not be familiar with the center, I'll just take a minute to explain who we are before we move on. We're an interdisciplinary think tank and research center here at UCLA Law School. We're working to support long-term legal and policy solutions that can advance all aspects of reproductive rights, health, and justice. And our goals are increasing access to abortion and contraception, ending racial and economic disparities in maternal health outcomes, and supporting people who decide to build families while dismantling the gender bias that limits reproductive justice. As our webinar title suggests, we think state constitutions are powerful tools for achieving those goals. And while state courts and constitutions have always been a potential source of stronger protection for abortion and reproductive rights, the move to develop law in the states has really exploded since the Supreme Court decision in Dobbs, which overruled Roe v. Wade, and with it, the constitutional protection for abortion rights at the federal level. So a developing part of this constitutional story in the states right now is the ratification and implementation of new amendments that explicitly protect abortion and reproductive freedom. So we are really lucky that we have today with us a chance to talk about how this is unfolding in real time and from people who are working on the front lines. So before I introduce them and begin the discussion, let me just do two quick housekeeping points. First, we are going to be saving time to take questions from the audience at the end of the discussion among the panelists. You can submit those through the Q&A function. I believe the chat function is going to be off, so I do ask people to use the Q&A to submit any questions at any point, and we'll be looking at those and try to get at as many of those in as we can at the end. The other thing is for attorneys who are seeking California MCLE credit, please note the reading materials are going to be put in the chat that are available online for you to access. And after the webinar is over, you are going to receive by email a form that you will need to complete in order to get the MCLE credit. So look for that later after the end of the presentation and discussion. Okay, so before diving into that discussion, let me introduce very quickly the speakers. You can find out more about them in the materials that were included in the chat. So first we have with us my colleague, Catherine Cohen. She's a staff attorney here at the center and co-author of our new report, The Promise of Reproductive Freedom Amendments, an analysis of state constitutional protections and their impact on anti-abortion laws. We also have with us from Ohio, Professor Jessie Hill, where she is the director of the Reproductive Rights Law Initiative at Case Western Reserve University. Professor Hill's teaching and legal scholarship focus on constitutional law, civil rights, reproductive rights, and law and religion. And she's also served as counsel in numerous challenges to abortion restrictions in Ohio, including litigation right now under the Ohio Reproductive Freedom Amendment, which we will be hearing about today. From Missouri, we have Tori Schaefer, the Director of Policy and Campaigns at the ACLU of Missouri. Tori has played a pivotal role in the campaign to pass Missouri's Reproductive Freedom Amendment and is part of the legal teams litigating multiple cases right now related to enforcing, and as we'll hear, defending the amendment from recent attacks from the legislature. And finally with us is Alexandra Willingham, staff attorney at the Center for Reproductive Rights, where she works on all aspects of the center's U.S. litigation across the country, including as counsel in Northland Family Planning versus Nestle, which is a case brought under Michigan's Reproductive Freedom Amendment. So we have representation from a number of states. And to start, what I'd like to do is dive in and hear about the national picture. So just before turning to that, I do want to point out that before and after Dobbs, several state high courts have recognized that their state constitutions do protect abortion rights. And generally, those were decisions reached under very broad guarantees like privacy or liberty or equality provisions. But before Dobbs, no state had an explicit reproductive freedom amendment. So this really is a tremendous shift. So I'd love to hear more about what the landscape looks like now, what's important to know about these new guarantees, and really the big picture overview that you can give us, Catherine.
Great, thank you so much. I'm just going to share a few slides. Thank you so much. Um, yeah, so as Diana mentioned, before Dobbs, the federal constitution protected the right to abortion in every state, but we did not have these state-specific reproductive freedom amendments. And rightfully, after the Supreme Court took away the federal right, many states and their voters were very concerned about access to abortion in the states. This led to a wave of campaigns to create new state level constitutional protections that were independent from any federal right. And notably, these campaigns happened both in states that already were very protective of abortion rights and also in states where there were already restrictions on the books that were waiting to go into effect or hostile governments that were already attempting or likely to try to ban or severely restrict abortion access. To date, there have been 10 states that have passed reproductive freedom amendments, or RFAs, you may hear us say throughout the webinar, which codify both the right to abortion, but other rights beyond this within their state constitution. And here at the center, we recently published a report which provides a comparative overview of these different amendments.
Catherine, sorry to interrupt. I don't know if it's for everyone, but the slides are not full screen, I don't think right
Hmm.
now. I just wanted to double check you have it in the presentation mode that you were intending.
I do, but if that is true, I can just do, let me see. Maybe I will just leave it as this for now. I know you can you see the ones on on the side, but you can still see at least all the content that way? Okay. And I can
Okay.
zoom in a little bit. Hopefully that will help. Thank you. Before I talk about the language and scope of the reproductive freedom amendments, it's helpful to understand the lay of the land in terms of abortion regulations and access in the states that passed them at the time that Dobbs came down. So, of the 10 states that passed reproductive freedom amendments, only three were states where criminal gestational abortion bans would be enforced, specifically Arizona, Missouri, and Ohio. But all 10 of the states did have some kind of abortion regulation on the books that impeded access in significant ways. There were more than 50 laws and regulations on the books in these 10 states at the time of Dobbs, and all of these could be implicated by the Reproductive Freedom Amendments. These laws include gestational limits on abortion, including viability limits, but they also include laws that ban abortions that are sought for a specific reason, such as sex, race, or fetal diagnosis, laws that require patients undergo specific counseling or delay access to care through waiting periods, bans on telemedicine or requirements that medication abortions take place in person, laws that limit the provision of abortion care to only physicians or some limited set of healthcare providers, laws that regulate abortion providers or facilities, or what we call TRAP laws, and also bans on private and public insurance for abortion care. And so by passing these amendments, even in states that already had protections for abortion care, but may have had some of these other regulations on the books, voters have created a tool for making abortion even more accessible in all of these states. And as we discuss and is shown on this slide, a number of these laws have already been temporarily or permanently enjoined, including in the cases that our panelists are going to be discussing today. Many of these laws have been on the books since before the Dobbs decision, and several of them have actually been upheld as constitutional under the prior federal standard. However, given that each of these amendments creates a new and independent state constitutional right, and none of them adopt or reference the prior federal standard, those past federal decisions don't mean that these laws would now pass constitutional muster, which is another very exciting advancement of these RFAs. Now to look a little bit at the language of the different RFAs in the states. As you will see on this slide, virtually all of the reproductive freedom amendments tie the new positive rights that they create to broader constitutional values, including autonomy, freedom, and equality. And even before these amendments were enacted, we saw that these principles have been invoked by state courts to find state level constitutional protections for abortion. And so the invocation of these values kind of can give a guide to how state courts might interpret the amendments. For example, in California, the state Supreme Court recognized a right to abortion several decades ago and grounded this right in privacy, equal protection, and due process. And similarly, in Montana, the state Supreme Court long ago recognized a right to abortion that is part of an explicitly stated right to privacy by finding that that right to privacy included procreative autonomy. Additionally, most of these reproductive freedom amendments codify rights beyond abortion. Only two, Colorado and Montana, are specifically limited just to the right to abortion, while the rest of them invoke other rights and reproductive freedoms and reproductive health care as well. Additionally, New York's Reproductive Freedom Amendment is actually an expansive equal rights amendment. But unlike many of the ERAs that were ratified in the 70s and 80s, this amendment very explicitly protects against discrimination based on pregnancy outcomes, reproductive health care, and autonomy. More than half of the amendments explicitly mention care and decisions related to continuing a pregnancy, and this could have some notable implications for maternal health rights, birth justice, family formation, and more. Additionally, 5 of the reproductive freedom amendments don't mention fetal viability at all, a point that was referenced in both the Roe and Casey standard, which gave all states the ability to regulate or ban abortion at the point of fetal viability. Pre-Dobbs, many state laws attempted to define the point of fetal viability based on gestation, but all 5 of these amendments define it in a way that recognizes that the point is different for each individual pregnancy and is affected by many factors that are specific to the pregnant person. And these 5 amendments all define fetal viability and require any restriction to be based on or require that any limitation of care be based on the good faith medical judgment of the treating healthcare physician professional for the specific pregnancy at issue. Most of the amendments are explicit about the standard of judicial review, and all of them require something more than Roe and Casey did. And as I mentioned, none of them adopt that prior federal standard. 5 of the amendments specifically specify that the only acceptable government interests are those related to the health of the pregnant patient and require these interests to be based on evidence-based clinical standards of care. This creates new guardrails for the courts that are interpreting any of these amendments and applying them to any restrictions. So by and large, almost all of these amendments have language that offer the potential for state courts to interpret them expansively and to have the amendments go beyond just striking down gestational bans, but also to implicate regulations that make it more difficult for people to access abortion, including laws that make access to abortion more expensive or time consuming, like waiting periods. Laws that specifically limit the ability of minors or youth to access care, like parental involvement laws, or laws that make abortion particularly difficult for low-income people to access, like Medicaid coverage bans. As we'll talk about today, we have already begun to see early and promising progress in using these amendments to challenge these restrictions in courts. But additionally, we think it's important to think about how legislators and policymakers have an obligation to implement these amendments, whether that be by repealing or amending restrictions in the law or by passing new laws to help achieve the goals of the reproductive freedom amendments. And I will pass it back. Thank you.
Hey, thanks, Catherine. I love that point that there's a lot to do to implement these, including the litigation, but beyond. So I guess given the landscape that you just overviewed, the question is how both policymakers and courts are going to implement the guarantees so that they are real for people living in these states. So let's talk about what that's look like. at least in the states we have represented here today. And Jesse, I'd like to start with you. Ohio did have a 6-week ban in place, or what is called a heartbeat ban by some, and many other abortion restrictions were at least on the books when the voters ratified the Reproductive Freedom Amendment there. And litigation had been pending both before and is ongoing now. Litigation, or at least new claims, were filed within a matter of months, I think, under the new Reproductive Freedom Amendment. So can maybe tell us about the strategy of going quickly to court with these additional claims under the new amendment, the types of legal arguments you're making in preterm Cleveland, the case that's included in the materials for those listening, and really where we're at and what's come of it so far.
Sure, thanks. Yeah. So, right. I mean, the thing about Ohio, what we knew from the beginning was that there was no path except a judicial one to implementing the constitutional amendment after it passed. So, in other words, our state government is still very hostile to abortion. And so the legislature was not about to pass laws repealing restrictions on the books, or, there was not going to be executive action either that could have been helpful. So we really knew that going to court was the only option, and we were pretty much ready to go when the amendment passed or shortly after. So, as you said, Diana, there were all these cases already actually pending in our state courts around that we had the 6-week ban, we had trap laws, we had a law regarding disposition of fetal tissue, we had a ban on telehealth. And some of those laws were already blocked as well under various theories, but we kind of knew that we were not going to, we knew our chances were going to get much tougher when we got before the Ohio Supreme Court because we didn't have explicit language that protected reproductive freedom. So once the amendment passed, first of all, the state actually immediately admitted that our 6-week ban was unconstitutional and couldn't be enforced. And so that was kind of a win off the bat, although they continued to litigate some kind of ancillary issues about that. And then we also amended our complaints to add new claims under the Reproductive Freedom Amendment, including, adding new challenges to laws that had already been on the books. So not only did we make our existing lawsuits stronger, but we were able to add a challenge to our Ohio has a 24-hour waiting period with an in-person visit requirement. So, you have to go in person 24 hours ahead of your abortion procedure, as well as various restrictions on abortion medication that makes it harder to access. It's like only can be provided by a physician in person. Up to a certain gestational stage that is lower than it's safe to do. So all of those actually we were able to go to court and get blocked pretty quickly as well. And what was really great, and Catherine was kind of alluding to this, is some of those laws, the mifepristone restrictions and the medication abortion restrictions and the waiting period and in-person requirements had already been challenged before unsuccessfully under the federal standard. And so we actually had such a concrete proof of what a difference the amendment made because the language was stronger than certainly than the period right before Dobbs. I think even stronger than under Roe v. Wade in my view. And so the court the courts were blocking restrictions that we couldn't do anything about in the past. So that was particularly gratifying. And as you mentioned, we've been winning so far, which is great. The one big question that remains, these cases are still working their way up through the courts, and they're all going to end up before the Ohio Supreme Court. And I think that's a big question mark still because it's a political body, because they're elected, because they are, 6 conservatives, one liberal, and about to be 7-0, probably after the next election in 2026. What are our chances going to be when we get up to that court is the big question. But so far, that it's made a really meaningful difference. And getting rid of the waiting period and in-person requirement in particular has been a really big benefit in the state.
Thanks, Jesse. And I really want to come back to something you said about it being stronger than Roe, but I do want to get all the cases on the table,
Okay.
and then we can come back to some of that. And you were talking about the importance of elections and how things can change as the case progresses. So that might be a good transition to Tori to talk about Missouri. So in Missouri, as in Ohio, ratification and amendment was very quickly followed by litigation, and you secured an injunction, right? It was successful in the comprehensive health case. I do think there's a lot of confusion, especially for people outside of Missouri, about the ping-ponging that happened between the initial injunction and it seeming to go straight up to the Supreme Court and back down, the state Supreme Court, of course. So, want you maybe to explain some of that for folks here, and also, of course, the new legislative initiative that is an attempt to full out repeal this amendment the voters of Missouri said they wanted to protect abortion and reproductive freedom in this state. So maybe you can just really clarify and get us all up to speed on what's happening in Missouri.
Absolutely. I like your use of the term ping-ponging back and forth because that's truly how this case feels from a lived experience perspective. So in Missouri, important history, very similarly situated to what Jesse just described about Ohio. We have a trifecta of anti-abortion politicians. We knew when we were moving forward with this amendment that litigation was always going to be the next step. In Missouri, our lived reality was virtually no abortion access even pre-Dobbs. Once the Dobbs decision came down, we were the first state to implement our trigger law via our attorney general. And that meant a total abortion ban. When we passed our effort, we were the first state in the country to end a total abortion ban, which is a fact that Missourians are very proud of. So after we passed this at the ballot box, less than 24 hours later, we filed a lawsuit with my team at the ACLU of Missouri, ACLU National, and our friends over at Planned Parenthood, representing our two Planned Parenthoods in the state of Missouri to cut through the books of the Missouri state statute, nearly 40 statutes in their subsections, to fully realize the right to reproductive freedom that Missourians passed the day before. By December 20th of this past year, we were able to get a preliminary injunction. And like I said, we were asking for 40 statutes to be struck. We had to file a motion to reconsider the preliminary injunction to strike through the abortion facility licensure requirements. That requirement was put on hold. And by February 14th, Valentine's Day, very memorable for our team, we, for the first time in a long time in Missouri, were able to provide procedural abortion care. Just a couple of weeks ago, I have to share with this group of folks who I know cares a lot about this issue. We were able to visit one of our clinics in Kansas City that is providing procedural abortion care for the first time in more than 20 years. So this impact is really felt by folks in Missouri. Meanwhile, our legislative session was going on. Our legislative session in Missouri runs January through May, and the legislature decided they didn't like the fact that we got a preliminary injunction put in place. So they literally wrote a new law to allow the attorney general to try and appeal our preliminary injunction. And then they also, as was alluded to earlier, passed a House Joint Resolution to try and strike through our constitutional amendment and ban abortion in the state of Missouri. Missourians will have the opportunity to vote on that in November. Meanwhile, while the preliminary injunction was in place, the Attorney General's office writted our judge, and a writ went out to the state Supreme Court. The state Supreme Court essentially said that the preliminary injunction that we were granted in February and in December were under the wrong standard. And so the judge had to vacate her motion. That decision from our state Supreme Court came at the end of May, and by July 3rd, we had the preliminary injunction back in place. So as you can imagine, that process and seeing those headlines was extraordinarily confusing for Missourians, and even our top supporters across the state who are very ingrained in this issue. And as of right now, right, we have procedural abortion care access. However, we do not allow Planned Parenthood clinics are not able to provide medication abortion. So just in the month of mid-September, we heard on September 10th, we were in two places in court at once on the appeal by the Attorney General's office to try and withdraw a preliminary injunction. Ultimately, we ended up winning that. Our preliminary injunction is still in place. And then over in Jackson County Courthouse, we were in a hearing about trying to allow Planned Parenthood clinics to be able to provide medication abortion. There's two regulations that are predominantly withholding that from being the reality in Missouri. The first one being tail insurance or supplemental insurance, a requirement that is medically unnecessary that Planned Parenthood the state thinks needs to have in order to provide medication abortion. That second requirement is called a comprehensive plan that Planned Parenthood would need to have to provide medication abortion. When they filed to try and get the paperwork approved to allow for them to have a compound, our Secretary of State put in an emergency rule that day that put on a whole bunch of an additional slew of medically unnecessary restrictions that rejected the comprehensive health care plan. So on September 10th, we had that hearing. We are currently awaiting for that decision. We feel really strong in our legal arguments that medication and abortion should be able to be realized in the state of Missouri, and our Planned Parenthood clinic should be able to provide that care. So that's currently where we're at in Missouri. And at the same time, today, we have a brief due in our case to challenge HJR 73, which is the ballot measure that's going to be voted on by Missourians, because not only does that ballot measure strike through our right to reproductive freedom, it also tries to put a ban on transgender healthcare for minors in our state constitution, which violates our constitution's single subject requirement that when you put something to the ballot, it can only deal with one subject, and also has an extraordinarily misleading ballot title, which is really important because it's the only thing that voters see when they go to check yes or no on the ballot. So as I hope you can see by me detailing the saga that we have lived throughout the past year in Missouri, the legislature is fighting us on all fronts to try and prevent that care from being realized. We currently have those lawsuits going on, and ultimately voters will have the opportunity to vote on the right to reproductive freedom again this coming November.
Okay, and just for clarification, we're in November now.
Next
So
November,
November
2026.
26. Yeah, that's what I thought, but just for everyone who's listening, so there's still some litigation around that new ballot initiative, but the one that is going to try and ban abortion and undo the Reproductive Freedom Amendment is likely going to end up on the ballot in November 26. So that is going to be an important time for people to engage. Okay, a lot there to unpack, and I'm sure people have questions, but I want to move on to Alex so we can get one more state on the table. And I think it's also interesting because it's a different political landscape, a little more, let's say, politically receptive, protective of reproductive rights. And I think the trajectory in Michigan it's also interesting in that, there was a combination of executive action, then legislative action and litigation. So it would be really interesting to hear about how maybe some of those strategies work together and why it was in, the view of folks on the ground and advocates still important to go to court and litigate, even though there had been some reforms coming from the other branches.
Yes, no, Diana, you described it extremely well. Michigan was on very different footing when this amendment was passed. The amendment was passed at the same time that Governor Whitmer was reelected, and she explicitly ran on reproductive rights, as well as Attorney General Dana Nessel. And so, yes, as soon as the amendment was passed, there was a flurry of activity. The executive action you mentioned, there was a big legislative repeal, and that repeal got rid of most of the conventional trap laws, which are described in the center's report. So those are things like laws governing the clinic facilities in a way that is designed to burden the clinic out of being able to do business. So those were all gone. But there was a group of laws that, in fact, are the ones most onerous to patients that failed to make it through the repeal. And fun fact, they did not get repealed due to a single vote from a Democratic lawmaker. So it's an excellent example of how Michigan is a blue state, but ... And so these laws are Michigan requires the Department of Health and Human Services in the state to generate these mandatory bias counseling materials. And these include fetal imagery that isn't to scale and makes patients think that very early pregnancies are much bigger than they actually are. They include information about parenting, such as safe sleeping practices, which is utterly irrelevant to someone who is seeking an abortion and is really just designed to try to convince you to do something other than obtain abortion care. You also have to look at descriptions of all abortion versions of abortion, regardless of whether those are care that is available to you given your the gestation of your pregnancy. So any patient in Michigan had to review those materials at least 24 hours ahead of their appointment. So they would either do that with a form online or by picking up the materials from a clinic. Many low-income folks in Michigan do not have access to a printer and or the internet, so this was extremely burdensome. And then the third requirement was, well, the third restriction is a provider ban. So only physicians were allowed to perform abortions in Michigan, which runs directly contrary to the vast majority of medical research about the safety of advanced practice clinicians, such as nurse midwives, in providing abortion care. And so we had these three really significant restrictions, still making it very difficult for Michiganders to access abortion care. With a state that has such significant rural populations and other medically underserved areas, these are all restrictions that make it very difficult to travel to receive abortion care and require Michiganders to travel much further than they would have to. And so we sort of saw our litigation as like the cleanup crew, that so much progress had been made already at the executive and legislative levels, but we really wanted to get this through and also provide an opportunity for the courts, especially the Michigan Supreme Court is a favorable court to this issue, we hope, to really define and construe this amendment. And a very good event for us early on is almost as soon as we filed, the Attorney General and the defendant agencies declined to defend the law. And so the Attorney General's office created this intervener group from Attorney General employees, but they're walled off from the rest of the Attorney General's office. And so it was a great look to have these entities all saying that they do not oppose. And then we also got a really fantastic draw in our judge. Michigan has a separate court for when you bring constitutional claims against the government that is actually staffed by members of the Court of Appeals in the state. And we were told we'd sort of get a 50-50 shot as to whether someone might be politically open to our claims. Michigan may technically be blue, but there is a lot of anti-abortion sentiment in the court system. But that was also an excellent start. And we had our trial in February. And in May, the court struck down all three provisions as violating the fundamental right to reproductive freedom, which was very exciting. So we are on appeal and things continue, but these laws are permanently enjoined.
Okay. Thanks so much, Alex. So all of your comments kind of like touch on two big things I want to talk about with all of you. How successful you are when you go into court, at least in the first instance, because the language seems to be so clear, and also the real impact the litigation is having on access, whether it is just, making abortion really available at all for the first time in some period of time, or expanding access by getting at these longstanding restrictions. So kind of two different topics, but let's start with the language of the amendments, because that is the really novel thing that we now have through these 10 different amendments. And I'm curious from any of you if you could speak to any particular language in the amendment in the state you're litigating in that you have found especially helpful in persuading the court or making your arguments. I'm particularly curious about the standards of review. Those look different. And Jesse, you did mention saying this is more than Roe. So any thoughts welcome from each one of you and all of you on that?
Sure, I can start. I mean, yeah, I
Okay.
think we had intentionally sort of so I had also helped with the drafting of the amendment, and part of the thought was to yeah, have language that is stronger than we even had under Roe, much less, and that much stronger than what happened after Roe kind of got diluted over the years and in the Planned Parenthood v. Casey decision, which brought the standard down even lower. So it's very specific in specifying that the state can only regulate reproductive decisions if it's doing so in order to advance patient health, they can't advance any other interest, including like, fetal life or some purported interest in potential life, can only advance the patient's health and only do so according to actual medical evidence when it's supported by actual medical evidence and standards of care. And it has to do so with using the least restrictive means possible. So it is a really, really like boxes the state in very much, leaves some room for reasonable regulations that are truly grounded in medical evidence, but that's about it. And so to protect patients. And so, that has been a really big boon. I think, also something that has been really powerful is that the law has like non-discrimination language, so it can't burden abortion or other reproductive decisions or interfere with them, but it also can't discriminate against that. And that's just has been a really powerful argument to have in your pocket because so many regulations single out abortion and treat it differently from other healthcare. And one of the big moves, post amendment has been to say, that's kind of the end of the story. If you're doing that, there's going to be no basis. And so, it's been a very sort of clean way to make arguments in court.
Seeing if anyone else wants to jump in on that before I throw out another question.
Yeah, I was very similar advantages in Michigan's amendment. The amendment very specifically calls out the precise language that establishes strict scrutiny. It says that the right to reproductive freedom cannot be burdened, infringed, or denied in furtherance of a state's compelling interest by the least restrictive means. And so when the intervener defending the law tried to say that something other than strict scrutiny applied, it was very easy for the court to dismiss that because that is textbook strict scrutiny. And then being able to really define what the state's relevant interests are, that it really is, again, as in Ohio, it is just patient health. And the amendment clarifies that it has to be patient health consistent with clinical practice and evidence-based medicine, and it cannot be detrimental to autonomous decision making. So there's a real kind of belt and suspenders there of just eliminating any way to try to sneak in non-scientific, non-medical reasons to regulate abortion. And in particular, that really excluded the state asserting an interest in fetal life in defending these laws, because that is not an interest that is allowed in the amendment text. And that also fetal life is what caused the Supreme Court to create undue burden, right, is the analysis. So there was this idea that there was something else, there was something on the other side of the scale. And so without that interest kind of tipping the scales, undue burden was just not remotely going to be the standard that was going to apply. We also have non-discrimination language. That is not something that the trial court ruled on, but we certainly made sure to talk about it and hope that will be given more teeth soon.
Okay. So it's interesting. I'm hearing both that there's language that clearly resonates with courts as this is what we know to be strict scrutiny, the most rigorous, but there's also this strict scrutiny plus element but we're going to tell you, the amendment's going to tell the court what a compelling justification having that written into the text of the amendments has been particularly powerful in the litigation. One thing though that comes up, and this is a harder issue area, is it goes beyond the prior precedent and standards. In some ways it's invoking, things that we're familiar with, like strict scrutiny. And as Catherine mentioned, there's 10 amendments, half of them do mention viability, right? Address the state having some authority to regulate. And that harkens back to, for many people, well, that was the Roe standard. So I know it's not an issue in any of these cases that we're talking about today, that I don't believe that's been any part of the litigation, but it might be in future litigation, if not in these states, in other states. And I'm curious if anyone has thoughts on how, again, not just courts, but policymakers, people thinking about legislation in these states should approach that language, given that these same amendments do create a fundamental right for the pregnant person. They do have these strict scrutiny or strict scrutiny plus standards, and they certainly don't require regulation at the point of viability. So I do want to put that out there and see if anyone has thoughts on thinking about that in a way that is not simply redoing Roe.
I mean, I'm happy to jump in again. This is like this is a very tough topic in a lot of ways, and it was a tough topic in the campaign leading up to the adoption of the amendment. I think so. Ohio is one of the states that has viability language, and I think if you look at that chart that Catherine helpfully created, like I think all of the states that have them are more red than all of the states that don't. And so, I think it's unfortunate in a lot of ways. I mean, I think nobody really, I think it's fair to say, and I'm only speaking from my experience in Ohio, but I think, nobody really wanted that language. It was put in there kind of as it was a strategic call that had to be made in the context of a campaign in a red state. I think one of the things that's important about it is what you said, Diana, that, that it doesn't create a viability limit. It doesn't say like abortion has to be banned after viability. It leaves room for advocacy and hopefully like culture change around this issue in states where, the viability issue or the issue of later abortions seem to really have potential to play a role in voters' views of the ballot initiatives. I mean, that's kind of where it came from. But I think, like I said, it kind of keeps us free to fight another day on this issue. And it is more protective than what the law was before. And again, I think a couple of folks have mentioned this. I mean, in Ohio, the language still subjects post-viability restrictions to having to advance the patient's health. And also, it has a broader definition or broader language around like health and reasonable physician judgment than what we had in the law before. So, to the extent that there's an ability to litigate those issues, I mean, we have good language there, but it's a very difficult question, especially in states like Ohio right now. That's just what I'll say.
Thanks, Jesse. And I appreciate that. I do think I sometimes hear people talking about some of the amendments as only creating a right up to viability. And so I think it's important to hear what you said and that there is room there. And also that that's not the language of all the amendments and they differed. So something to think about and, for those who are looking how to implement these going forward. I guess unless anyone else wanted to jump in, I was just going to change gears a little bit and ask as a more practical matter, two questions, but I shouldn't do that bad form of deposition where I throw two questions out. I'll give you one to start. What has been maybe some of the biggest or unexpected challenges? So, right, it sounded like a lot of initial successes. Obviously, there was a lot of challenges we heard about in Missouri, and concern about what happens on appeal. But maybe in terms of just the goals of expanding access, Tori, you mentioned a little bit about this, how there's been these other attacks from different amendments to the law after the litigation. So I'd be really interested in people's thoughts and maybe just lessons learned for others about some of the things that, what the court says isn't going to totally address the issue of increasing access because of other barriers in the state that maybe haven't been challenged or pushback you've seen in unexpected ways.
I mean, for us, in our case, right, we were very eager to get that preliminary injunction, which is why we filed less than 24 hours after the election. And so, I wouldn't say unexpected. We knew opposition was going to try and get that preliminary injunction taken away. But creating entirely new laws to attack our lawsuit while it was moving is something definitely our litigation team did not have experience with, right? It's a very unique problem to be going back into your lawsuit and amending to cover laws as they are being developed. And at the same time as that lawsuit is going on, I didn't say this earlier, but our trial actually is in January of 2026. And so that is coming up. And the slew of, as everybody knows, depositions and discovery going on, we also have a campaign that is moving to the ballot, right? And so at the same time as you're doing litigation to fully realize and actualize this right, you are preparing your community to fight for this at the ballot again. And I think that really speaks to what I heard Jesse saying earlier is you need to give space for the fight to continue. You need to give space for the right to fully be actualized and at the same time continue to protect it and fight against the decades and decades of misinformation and disinformation around abortion care that we've had in the state of Missouri.
Thanks, Tori. What about in Ohio, Michigan? Any lessons learned there, unexpected
We
turns?
were we were a little surprised in Michigan, having, crowed that it was so great that the AG and the licensing and health regulators didn't oppose. We were maybe a little shocked at how vigorously the interveners defended the laws. And I mean, they would probably say that they are rigorously defending their client. But they insisted on a massive amount of discovery that we didn't find to be particularly relevant and seemed to just be designed to be onerous. And then, despite the senior leadership's attitudes towards these laws, the litigation intervener team then brought on a couple of classic anti-abortion experts to defend these laws at trial, people who have appeared defending laws around the country, are both very much on the public record saying that abortion is an abomination that should never happen. And again, the language of the amendment was very protective for a lot of that, right? And these experts were not able to prove that their testimony was consistent with clinical practice or evidence-based medicine, et cetera. But it was a good reminder that even in a friendly state where we're, quote, suing our friends, it can be a slog.
I think the thing that has struck me in Ohio is that although we've had a lot of success so far in bringing down legal barriers, we lost so many clinics in the decades, between Roe and Dobbs, and there we were down to like about 6 procedural abortion clinics, and now I think there are 7. There was one medication only that started providing procedural abortion as well, but it just hasn't been it's much harder to actually increase access in that way. There's so many not exactly legal barriers, but just sort of decades of sort of structural barriers of the combination of funding restrictions and insurance not covering and the red tape of these again these clinic laws and the cost barriers to open them and the availability of physicians to provide them or advanced practice clinicians to provide them, and it's just been it has been slower and harder to expand access on the ground than in terms of at least having more facilities than it seemed like it should have been, given how much this just sort of opened things back up again.
Yeah. Um, One thing you said, Alex, that I wanted to hear more about, and then I have a follow-up for you, Jesse, on the access. You were talking about, the onerous kind of discovery sought from the other side, not relevant, and also that part of what's written into these amendments and is really helping the litigation is that the state's interest, has to be supported by based in real evidence and science, and so I'm curious if ha- that's pretty unique, I think, to reproductive freedom amendments in terms of constitutional language. I'm not familiar with other constitutional amendments that have maybe that level of detail in terms of what can satisfy having an evidence-based standard written into constitutional law. Maybe it does exist in some other context, environmental context, but has that been actually required a lot of production of evidence on the side of the plaintiffs in these cases, or has that in any way added to the litigation burden? Right, we're kind of talking about how everything in there is so helpful. So I'm just putting out there: is there anything in there that's made it more challenging in some way, or it's just really coming from the abusive, maybe discovery on the other side?
It was challenging, but I think maybe not in the way that you are getting at or that you might think would be the case in for my evidence nerds out there, there is a Michigan does not permit uh using learned treatises as evidence at trial. So we are very used to putting in treatises to buttress our experts. Our experts can directly cite treatises as evidence to show that they know what they're talking about. But in Michigan, you don't do that. And so we had to coach our what we had to prepare our experts to sort of summarize the field and say, well, yes, there's experts that say this, there's experts that say that, but they can't actually pull anything up. So I really felt for our fact finder because of that. So it was less of a production burden, but it was a strategic burden to change our litigation practices to make that work.
It's interesting, right? Moving every state has very different rules and processes in terms of how evidence is entered and what the rules are. So another important consideration in folks who may be used to advocating in federal courts under federal constitutional claims. The other thing that was coming out was, all these existing barriers that maybe aren't abortion restrictions explicitly, but on the other hand, while these cases do challenge a lot of the abortion restrictions, they don't challenge all of the types of abortion restrictions that are out there. And I'm curious if people have thoughts on the other areas of abortion regulation restriction that still require, under these reproductive freedom amendments, further reform. Again, whether it's the possibility of future litigation or real effort, in states where it's possible, policy reform.
I can jump
Takers?
in that Michigan already has other litigation in the works, and I want to, give them credit that so there is a wholly separate litigation, again under the amendment, challenging Michigan's ban on the use of public funds for abortion. So that was brought by the YWCA of Kalamazoo, represented by the ACLU. And unfortunately, they got a far less sympathetic draw in a judge. And so they were kicked out on standing, despite Michigan having a very liberal standing doctrine compared to the federal standard. The court said the organizational plaintiff lacked a direct harm to itself. But I can't say that I found that to be very persuasive. So that'll be very interesting on appeal. And I hope that they have more success in front of other courts. And then I think just last week, If, When, How, and Compassion Legal filed a challenge to the ban on applying advance directives when the patient is pregnant.
Mhm.
And so these are, I don't think I really need to explain why these are both infringements of reproductive decision making as protected in the amendment. So it's very exciting to see where those will go. And then something that has not happened, but there's a lot of conversation in the state, is Michigan has a parental consent law. And we do treat minors differently in many aspects of the law, but the amendment certainly does not. And the the idea that a minor in judicial bypass for the parental consent has to be deemed mature enough to have an abortion, but it doesn't matter whether she's mature enough to be pregnant for 9 months and give birth and potentially parent, is just a wild inversion that is the case in many states and has been for a long time. But it would be very exciting to test that under this amendment.
Yeah. I think that's an interesting point you make, in that the amendments don't speak to that specifically. They don't create a different or lesser right for minors. And I should note, the report doesn't look at parental involvement laws were an area we did not canvass just because of, the breadth of what was out there already, but because it does require its own look, in that you have fundamental rights of minors have been established in lots of areas. And so this is a question I think that is, and there has been litigation filed by other organizations. So I do think that's something for everybody to think about and keep an eye on. I'm mindful that we only actually have 4 minutes left. I know at least a couple questions that were put in the Q&A got some direct answers, but please put them in very quickly if you want me to have time to pick them up. And while keeping an eye on that, I do want to ask everyone maybe to think a little bigger, broader. We've been focused on abortion restrictions. Our report was focused on that, but obviously these are reproductive freedom amendments, as Catherine was mentioning. They have a lot of language, and all of you have mentioned that apply broadly. So I would love to hear in the time we have left from each of you where you think there could be important advances to protect pregnant people or people's reproductive decision making in other contexts beyond abortion, and why the amendments in each of these states, maybe by virtue of their language or the voters' intent in passing these, that it would be really important for people to start thinking about how to implement them in these other contexts. So I'm gonna hand it over to someone to get it started. Tori, do you want to jump in on that?
Yeah. Well, we were drafting our amendment. We included in the right to reproductive freedom explicitly the language around respectful birthing conditions. And throughout the campaign, and even now to this day, folks ask, like, what does that mean? And the impetus behind that was because in Missouri, for the past 9 years, it has been illegal for state prisons to allow shackling of pregnant people who are incarcerated and giving birth. That restriction only applies to our state prison, but did not apply and does not apply to our city and county jails. And while there has been legislation to do that, to prohibit the shackling of pregnant people or while people are giving birth, we wanted to put in this constitutional amendment some teeth that would allow us to prevent that in the city and county jails in the same way that is prevented in state prisons. And so that way, people who are giving birth do not have to do so while being physically restrained.
That's fascinating. I love that, knowing that history, and I also love that it was put in there in a way that definitely covers that, but not only that, because it is respectful birthing conditions for everyone. So,
Absolutely.
um, others, thoughts on areas these amendments need to be applied, can be applied beyond abortion?
I mean, in Ohio, I think some of the issues are around there are birth centers that interestingly face some of the same challenges as clinics, although for maybe different reasons. A lot of times, like they need a relationship with a hospital, and hospitals are kind of engaging in anti-competitive behaviors and don't want to like give them the contract that they need. And so but it is something that seems open, certainly to challenge if it's not based in medical, need, these restrictions on birth centers. And then, like, I think another big issue in Ohio, as in a lot of states, is fertility care, both, in vitro fertilization, and which is very expensive, and there's no state requirement for coverage of that. But also like fertility preservation as well for people who might be undergoing medical procedures that affect their fertility. So I think these are both areas to, again, sort of on the growth edge of this issue.
And then I was just going to highlight one example that is mentioned in our report, which is in Vermont. There was a case filed by Pregnancy Justice and the ACLU using Vermont's Reproductive Freedom Amendment to challenge the involvement of Child Protective Services against a woman who was currently pregnant. They wanted her to get a C-section, and they actually tried to take custody of her fetus before giving birth, which is not the realm of Child Protective Services at all. And then also to take custody of the child after they were ultimately born. And so that is being challenged under the Reproductive Freedom Amendment as a violation of her reproductive rights. So we really are seeing kind of the potential for these to go into people's right to make decisions about their pregnancy and also their right to parent.
Thanks, Catherine. It's a good point, along with the advanced directive case, Alex, that you were mentioning. I think there's a lot of long-standing practices, some that are well-known, some that aren't that treat pregnant people differently in all sorts of ways. And these amendments are a real resource and tool for attacking those kinds of violations of rights, which are sometimes not about the decision whether to continue or end a pregnancy, but the equal treatment of people who are pregnant. We are at the hour. We're actually out of time. So I just want to thank our wonderful panelists for sharing these really behind the scenes insights from the different states working where advocates are working so hard to implement the amendments that the voters passed, and everybody who joined us today. If you want any more information on the cases, on the different state amendments, those are all easily accessible in the links in the chat. And I'm just double checking. Yeah, I think we are out of time. So I'm going to cut it there with the thanks to everyone who joined us again, and have a good afternoon.